Right now, at this very moment, the Supreme Court is deciding whether the most popular rifle in America can be banned. We're talking about the AR-15. Millions of Americans own one. But some courts are saying it's not protected by the Second Amendment at all. Think about that for a second. The gun that millions of law-abiding citizens own for self-defense, sport shooting, and protecting their families could be declared illegal to own, sell, or even transfer to someone else. This isn't some far-off possibility. This is happening right now, and the Supreme Court is about to make a decision that could change gun rights in America forever. There's a case called Beavis versus Cook County that's sitting on the Supreme Court's desk right now. This Friday, January 9th, the justices will meet again to discuss whether they're going to take this case. Here's what this case is about. Cook County in Illinois passed a law that makes it a crime to sell, transfer, or even possess what they call assault weapons. And what do they mean by assault weapons? Over 100 different rifles are banned by name, including all AR-15s and AK-47 style rifles. But it gets worse. They also ban guns based on features. If your semi-automatic rifle has a pistol grip, a folding stock, or a muzzle brake, it's automatically classified as an assault weapon. Just like that, your gun is illegal. The people challenging this law are regular citizens and gun rights organizations. They're saying this ban doesn't just regulate guns. It completely outlaws some of the most common rifles in America. Rifles that are supposed to be protected by the Second Amendment. The Supreme Court has already ruled on gun rights in major cases like Heller and Bruin. In those cases, the court said that Americans have a constitutional right to own firearms for self-defense. The court also said that guns in common use are protected by the Second Amendment. Well, guess what? AR-15s are incredibly common. There are millions of them in America. They're the most popular rifle in the country. By the Supreme Court's own standards, they should be protected, but lower courts are ignoring this. They're coming up with creative reasons to ban AR-15s anyway. Here's where it gets really frustrating. The Seventh Circuit Court, which covers Illinois, decided another case called Beavis versus Naperville. In that case, they said AR-15s are too militaristic to be protected by the Second Amendment. Wait, what? Too militaristic? The court said that because AR-15s are similar to M16s, which are military rifles, they can be banned. They claimed that any firearm useful in military service can be outlawed. But here's the problem with that logic. It contradicts everything the Supreme Court has said about gun rights. In fact, the Supreme Court has historically protected arms that have militia or defensive use. That's the entire point of the Second Amendment. Think about the muskets and rifles that existed when the Second Amendment was written. Those were military weapons. The same guns soldiers used were the guns citizens owned. That was by design. So saying a gun is too military to be protected makes no sense. It's exactly backwards. The district court in Cook County was bound by what the Seventh Circuit decided. So even though there are strong arguments that AR-15s should be protected, the lower court ruled against the gun owners. The court issued something called summary judgment in favor of Cook County. That means they decided the case without even going to trial. They just said, based on the Seventh Circuit's ruling, AR-15s aren't protected. Case closed. The gun owners appealed. But the Seventh Circuit refused to review the case properly. They basically just rubber-stamped the lower court's decision and said AR-15s are civilian versions of M16s, so they're not protected. This left gun owners with only one option: appeal to the Supreme Court. The people challenging this ban are making several important arguments. First, they say the circuit courts across America are split and confused. Some courts say AR-15s are protected arms but can be heavily regulated anyway. Other courts say they're not protected arms at all. This inconsistency is a huge problem. Second, they argue that the whole useful in military service test that courts are using never came from the Supreme Court's rulings in Heller or Bruin. Lower courts basically made it up, and now they're using this made-up test to ban millions of guns. Third, they point out that AR-15s are exactly the kind of firearms the Second Amendment protects. They're in common use. They're effective for self-defense. They're not unusual or dangerous weapons. The gun owners are asking the Supreme Court to clarify once and for all. Do Americans have a constitutional right to own AR-15s and similar semi-automatic rifles? Cook County doesn't want the Supreme Court to take this case. They filed a response arguing that the court should just deny review and move on. Their arguments? They claim this case has procedural problems. They say the legal questions are already settled. They insist this isn't the right case for the Supreme Court to review. In other words, they're trying every argument they can think of to avoid the Supreme Court looking at their rifle ban. Why? Because they probably know that if the Supreme Court actually reviews this case seriously, their ban won't survive. Here's something really important. Last term, the Supreme Court denied review of another rifle ban case called Snope. When they denied that case, Justice Kavanaugh wrote a statement. He said the time would come very soon when the Supreme Court would need to take up a rifle ban case. He said this would happen in a term or two. Well, guess what? We're now in that time frame. Justice Kavanaugh made a promise. The question is, will he keep it? The gun owners in this case are pointing directly to Kavanaugh's statement. They're saying, "You told us you'd take a rifle ban case. Here it is. This is the perfect case." Now, here's where things get interesting and a little concerning. This case has been relisted by the Supreme Court multiple times. This Friday will be the third time the justices meet to discuss it. What does relisting mean? It means the court didn't decide whether to take the case, so they scheduled it for another conference to discuss it again. According to data from previous Supreme Court terms, cases that get relisted once have a much better chance of being accepted for review. Between 31% and 43% of cases relisted once eventually get heard by the court. But multiple relistings? That's usually not a good sign. It often means the court is going to deny the case, and one or more justices want to write a dissenting opinion explaining why they disagree with denying it. However, there are exceptions. Some cases get relisted many times and still get accepted. The bump stock case, for example, was relisted over 10 times, and the court still took it. So multiple relistings don't automatically mean bad news, but they do raise concerns. There's also another case being considered at the same time called Duncan. This case challenges California's magazine ban, which prohibits magazines that hold more than 10 rounds. This case is also being relisted along with the Cook County rifle ban case. Both are heading to conference this Friday. The fact that both cases have survived multiple conferences while other gun rights cases were denied outright might be a good sign. It suggests at least some justices are interested in taking up these issues. For years, the Supreme Court has avoided the rifle ban and magazine ban question. They've denied case after case, leaving lower courts to do whatever they want. This has created chaos. Different parts of the country have completely different rules about what guns you can own. In some states, AR-15s are perfectly legal and protected. In others, you can be arrested just for possessing one. This is exactly the kind of situation the Supreme Court is supposed to fix. When federal appeals courts disagree about what the Constitution means, the Supreme Court should step in and provide clarity. But they haven't. At least, not yet. This Friday, January 9th, the Supreme Court will meet in conference. They'll discuss these cases again. Then, in the following week, they'll release an order list. That order list will tell us one of three things. 1. The court grants review. This means they'll hear the case, consider the arguments, and issue a ruling that applies to the whole country. 2. The court denies review. This means the lower court's decision stands, and the gun ban remains in effect in Cook County and potentially spreads to other areas. 3. The court relists the case again. This means they're still not ready to decide and will discuss it at yet another conference. If the Supreme Court takes this case and rules in favor of gun owners, it would be a massive victory. It would mean that AR-15s and similar rifles are constitutionally protected across America. States and counties couldn't just ban them outright anymore. If the court denies the case, it's devastating. It means lower courts can continue banning common rifles, and gun owners have no recourse. The Second Amendment would be hollow in parts of the country. This case is about more than just AR-15s. It's about whether the Second Amendment actually means something. The Supreme Court has said that Americans have a right to keep and bear arms. But if the government can ban the most common rifle in America, what does that right actually protect? Only the guns the government decides you can have? That's not how constitutional rights work. You don't get to exercise your freedom of speech only if the government approves of what you want to say. You don't get religious freedom only for government-approved religions. The same principle applies to the Second Amendment. If it's a real constitutional right, It has to protect the arms Americans actually use and want to own for lawful purposes. We're at a critical moment. The Supreme Court has the opportunity to finally provide clarity on rifle bans and magazine bans. They have the chance to protect the rights of millions of Americans who own AR-15s for lawful purposes. Will they take that opportunity? We'll find out very soon. Justice Kavanaugh said the court would take up this issue in a term or two. Well, the time is now. The case is ready. The question is clear. Will the Supreme Court keep that promise? All eyes will be on the Supreme Court this Friday and then on the order list the following week. The future of gun rights in America could be decided in the next few days. This is a moment where the Supreme Court needs to do its job. Lower courts are in conflict. Constitutional rights are at stake. Millions of Americans are waiting for an answer. The question before the court is simple. Does the Second Amendment protect the right to own an AR-15? Americans deserve an answer, and they deserve it now.